So Gerard, I'll start with you. This panel discussion is about the latest cases in South Africa and Zambia. We've only narrowed it down to three, just three of the most recent, most relevant. And each of the guys on stage are going to take us through. So Gerard, I'll start with you. I believe that there is a Nivea case that went down, and Nivea was successful despite that they weren't using that particular get-up. Can you please just take us through the case?
Lita, yes, thanks. Good afternoon, everyone. You gave away the answer of my next slide, but so the case that I intend to summarize for you is one concerning quite an unusual case of passing off that required us, or the facts of which required us to dig a bit deeper into our toolbox, almost towards the bottom to find the right tool for the job. And it reminded me that the fact that a specific tool has not been used for a while, perhaps because it's hidden underneath the more modern, more popular tools, does not mean that it should be discounted or discarded. So let me, before you think that I'm making myself out to be a bit of a handyman, which I certainly am not, let's get onto the facts of the case. Oopsie, that's one too far. Okay. Well, there you have it. There is the problem. There's a slight case of dishonesty on my part because I blocked out the trademark. But does this remind you of any product? Perhaps my Nivea blue tie gives a bit of a hint. But yes, it is a shower gel product for men. Certainly, it does look and feel like a well-known product, the real product. Let's move on to what it's meant to refer to. This is the current range of Nivea for Men shower gel products. This particular range has been on the market in its current packaging for the last 5 years or so. As I said, I was a bit naughty when I blocked out the trademark, and I did it for a specific reason of the infringing product. So a better comparison should be this. So there's a bit of a delay in the slides. It's not moving on. Can we just move to the next slide? Yeah. So there you have a more fair comparison. So on the left-hand side, you see the product. It's got the trademark Connie on it. On the right-hand side, you see the same three bottles that you saw on the previous slide with the Nivea trademark on it. Now, this immediately shows that there are a few problems. The first one is that the trademarks themselves are quite different. They are distinguishable. They're not really in any way similar, which normally is a problem in a passing off case. And of course, there are similarities. There are some color schemes, perhaps shapes of the bottles, but there are clear differences. So if you view them side by side, it's not a case that at a first glance you are likely to succeed with. So let's have a look at the specific challenges we had. So let's click it. Let's look at the trademarks first. So on the left-hand side, Nivea Connie, they're not visually, phonetically, or conceptually similar. Yes, both in white lettering perhaps, but you would have noticed that there is an issue with the shape of the label perhaps. The difficulty that we had for Nivea was that that particular label was discontinued in 2012 already. So what Coney did is they used elements from previous packaging of the Nivea range. So if you compare these two side by side, not close enough. Incidentally, because the Nivea label was discontinued, the trademark was also not renewed in 2016, so it had lapsed. We couldn't rely on infringement. But in any event, even if the registration was still valid, they're not similar enough to constitute infringement. So the first challenge was the trademarks were dissimilar. The second challenge concerned the fact that a lot of the elements were not on our packaging anymore. So we were trying to base an argument on a residual reputation still existing in relation to discontinued elements. And the third one was that the color scheme was not unique. There are other brands also for men's shower gels like Vaseline and others with blue and silver. So just to go through the sequence, some of the labels you might recognize. From 2006 to 2009, the first one top left was used. Then the wavy one that they copied, only used for a short period, from 2010 to 2012. In 2012, they adopted a new label also for a short period. And from 2013 to date, the round logo that you saw on the current range. So at the time that this case was brought, for more than 5 years, no use of the wavy label. So is that something that we can use? So to give you a better idea of how the actual packaging changed, you can see there's at the bottom the range that was discontinued in 2012 with the label in the wave appearance. So this is perhaps the way to compare the get-up. Now you can imagine that our opponents went to great lengths to say, but which product are we accused of passing off? Show us the one product that we copied, and let's do the comparison in terms of the case law. And we said, you can't look at one, you have to look at more than one. And they said, but it's an invalid comparison. You're not selling those. You abandoned those elements. And that was the challenge that we were faced with. So we decided, let's first look at what reputation we can allege in the packaging. So the Nivea trademark, no doubt it's a very prominent brand, well known. So we looked at our sales figures over the 5 years preceding the court case, and sales of Nivea in South Africa grew from 2012, 894 million to 1.7 billion in 2017. And only for the shower gel, from 2012, 24 million to 54 million, so it's sort of sizable sales. But if you looked at the market share, even more impressive. So the Nivea men range from September 2011 grew from 36%, where it was already the market leader, to almost 60% in September 2013. So it was by far the market leader. And this is how the judge sort of looked at the case. The first quote, it's not disputed that the Nivea brand has a hefty reputation. That's all fair and well, but it doesn't help us. That is Nivea, the trademark. But then the judge summarized our approach as follows. She says, the applicant complains that the Connie getup has borrowed from the applicant's stable of distinctive logos and features, both past and present, so as to create a composite which is deceptive to the consumer. And that's exactly what we tried to put a case that we tried to put forward. Now, obviously there were differences between the two products. The trademark one, the actual shape of the bottle, the layout was not identical. But the judge said, but let's have a look at the similarities. Firstly, the wave label that I referred to earlier, because of the reputation, it does not matter that we discontinued use. The color scheme, the blue, white, and silver, and there might be others, but we are by far the market leader. The bright green lettering, there was a previous slide that showed the 3 bottles, same positioning, same font, same color code. Also the splash in the center of the bottle, that was copied, the exact location of that, and the container, similar height, width, and volume. And then the judge came with these comments which really summarized our arguments, and I'm very happy to say that she agreed with our arguments. So she said that the hallmarks in getup and logo have the potential to retain reputation through changes and rebrands. So through the refreshing of the packaging, we did not lose rights in the elements of the getup. Indeed, it's not unusual for historical brandings to be revisited in the market to invoke nostalgia and a sense of staying power. That's quite a strong statement to make. And then she specifically said it matters not that the use of such parts has been discontinued. And then finally, in finding in favor of Nivea, she said the hallmarks of the applicant's past getups have created impressions and associations which linger in the minds of consumers. The employment of these features is plainly evocative of the applicant's brand. So she accepted that consumers can be confused, and fortunately the one piece of evidence we had in our favor was an instance of actual confusion. It was a former partner of ours that came to me one day with the packaging, said that she bought it for her husband. He had used it for almost 3 weeks before noticing it's not Nivea. And that's how this whole case started. But Be that as it may, at least now you can rely on a residual reputation in past elements of former packaging.
No, perfect. Thanks, Gerard. I won't say any comments about husbands. But they can be great. That's all I'll say. You obviously agree with the decision. I mean, this is your matter. You won.
Yes.
You wanted it there. The judge was, was sensible. I read the judgment. She dealt with it, cut it down to size, and I think that's the kind of adjudicator you want dealing with your matters. But this is good and well. I mean, Nivea's got a great reputation. In South Africa, you could have a client who could have a packaging that they've used for years. They may not be able to establish the reputation, not quite with those figures. Where does that put them? Would there be a solution for them?
Lita, yes, it's a factual question. So as long as they can still prove a reputation in terms of the standard test, that it's known to a substantial number of individuals interested in the goods, doesn't have to be the market leader, doesn't have to have 60% market share, as long as it's not an insignificant or negligible number of consumers, in theory, you should be able to claim the reputation.
Okay.
And of course, the stronger the brand, I think the longer the duration of the reputation subsequent to the discontinuing.
Okay. So you said residual reputation. Does this now open the floodgates for someone to say, oh, I remember my thing was famous 15 years ago. I'm going to sue this person today. Does this open the floodgates for these types of matters to come before the court?
I don't think so. I think fortunately this test case we had a strong brand and a brand and a market leader. So, but again back to the previous question, I think it all depends on the facts if you can prove a common law reputation. It's unlikely if you used it on a small scale a long time ago, maybe not a commercial context, that you'll be able to prove that the legal reputation required. But it depends on the facts. It's not impossible.
So give us take-home points. So if I'm a local person here, I've got a business, how do I gear myself up to prove that reputation if I need to? And I don't quite have the reputation of Nivea.
Well,
what would you say I should do?
When we had the case, I was concerned about the frequent refreshing of the brand, whether that's not weakening the brand. But the court, and of course the court said much more than what I put on the slides, said that rebranding does not weaken the brand. There are still recognizable elements. So if you rebrand, try not to move away to something entirely different. It must still be sort of look like horses from the same stable. And again, you must think about, before you allow your trademarks to lapse, you never know when you need that tool from the bottom of the box.
So we must just renew them.
Forever.
Awesome, thanks, Gerard. Jamil, I'll move over to you. Is that the next? Okay, so Jamil, before you get into your case, so your case is Zambia. And we have a situation there where a person who has an international registration was able to enforce that international registration, despite the fact that in Zambia you can't rely on prior use. Okay. I know I'm saying like technical things now, so I want you to kind of preface your talk by first explaining to us what are we talking about? What is an international trademark registration?
Well, when you register a trademark, trademarks are jurisdictional, and I do talk in my slides about the various ways you can register a trademark. Typically, you register a trademark at a national registry in a particular jurisdiction. There are also regional trademark systems where you can register your mark via a regional system, and then you get rights in numerous countries, such as the ORP system or the EU trademark system. We also have what we call the Madrid system. This is an international system where there are more than 100 countries that are now member states. And by filing a single application, you can then designate any of the member states that you so choose, and you can thereby acquire rights in numerous states. The advantages of this are practical advantages such as lower costs, more or less effort, and the time will be expedited. So that's what an international registration constitutes. The enforceability of international registrations is somewhat dubious, especially in Africa. We've not always implemented the correct tools, or we've not put in place the correct legislation to bring or to domesticate the Madrid system. The case that I talked to is a matter in Zambia. Zambia has not yet domesticated the Madrid system, yet the registry found that the mark or an international registration designating Zambia is enforceable. And I'll go through more detail about that in the...
That is very curious. Take us through what happened in the case.
Excellent. So as I indicated, you've got several filing systems. I'm not going to go through them again. I'm dealing in particular with the Madrid system here. It's an international trademark filing system. And in Zambia, or what's happened in this particular case, an application was filed for the mark Betasol. I'm going to jump a few slides ahead. And the mark was accepted by the registry and subsequently advertised for opposition purposes. An international proprietor out of Italy had filed an earlier international registration, which was accepted by the registry and subsequently placed on the register. And they opposed the mark, and hence I refer to them as the opponent. The applicant then contested that the international registration is valid and argued that you cannot oppose my mark because your international registration cannot be valid in Zambia based on the fact that you had not yet domesticated the Madrid system. Now, the reason for the wanting of domestication is because what happens in any legal system, you either have a civil law system, and this may be a slightly artificial separation of the systems, but just to give you an idea, or you have what we call a common law system. And South Africa, or typically Zambia, has a common law system where we view our local laws as separate from the international law. And if you want to bring in an international law into your local law, you must then domesticate it. So you'll go to Parliament, and you'll incorporate it into your own law. Civil law countries would generally not have that distinction. Zambia specifically, like South Africa, is what we refer to as a dual system. Now, as Zambia had not domesticated the law, the argument that the applicant had was that if you have not domesticated it, an international registration should have no force and effect in Zambia. And they also referred to what was earlier said by Lita, referring to the case of Dej Brothers versus Olivine, where the court had determined in Zambia that you cannot rely on prior rights. So if you don't have a registration, you cannot oppose the trademark. You cannot rely on your prior use. The applicant argued that if you cannot rely on prior use and if your international registration is invalid, you have no basis to contest our application. The opponent, however, argued that we filed a valid international registration. We went through the process. It's registered as far as its designation to Zambia is concerned, and hence it's on the register, and we are relying on it. The registrar then took to considering both arguments, and the registrar found that there's, in his own words, a plethora of cases that deal with this matter, and referred to many Supreme Court of Appeal cases which said that if we have not domesticated the international legislation, it's not valid in the country and therefore not enforceable. Notwithstanding these Supreme Court cases, the registrar then referred to other various court cases, and if I recall correctly, all of them were lower court cases in which the courts had then said that you can take cognizance, you can take judicial notice of international law when interpreting local laws where you are seeking guidance. And this is very much the case in South Africa as well. But judicial notice is a very limited discretion that the court has. It's normally discretion that the court exercises in recognizing notorious facts of evidence, such as, is a mark well known? Is Kentucky Fried Chicken well known? A court would be entitled to say, yes, we would consider it well known, given the presence in South Africa. It's virtually in every city, multiple branches, etc., etc. But what the registrar had chosen to do here was it chosen to take judicial notice of the international law and say that international registrations are valid, given that Zambia has now ceded to the protocol. Although it's not domesticated, the protocol is yet. There's a clear intent to enforce it. Now, I have significant misgivings with the finding of the registrar, but be that as it may, the registrar then comes to the conclusion that it's enforceable and then relies on the international registration and fines for the opponent, and the mark of the applicant is subsequently rejected. Although I disagree with the substance of the argument and using judicial notice, which cannot found rights. After all, trademarks are statutory rights, and you cannot found it by judicial notice. I also agree with the proposal or the proposition of the Supreme Court earlier that you must domesticate international law before it can be considered to be a part of the local laws. However, we are now sitting with a mark that is physically on the register. So this would be no different to where I apply for a mark and the mark is mistakenly entered onto the register, or for failure of a party to oppose the mark succeeds, or the registrar simply makes a mistake, doesn't take cognizance of what's on the register and allows that mark onto the register. So the mark is de facto on the register, and as a result of being de facto on the register, it is valid until somebody cancels the mark. So I think the finding of the registrar in the circumstances allowing the international registration to be a basis for opposition is correct. The rationale that international registrations are necessarily enforceable, I think, is open to debate. I think that a party that would be subject to infringement suit based on an international registration would have the option to perhaps approach a court and say, well, the laws have not been domesticated. This registration, in turn, is not validly registered in Zambia and therefore should be cancelled. So they could counter-sue for cancellation of that international registration. Now, to some extent, all of these developments are maybe moot, because what's happening in most countries is that you find that the laws are changing and that countries are domesticating the laws. And in Zambia itself, what's currently happening is we find that they are in the process of amending their laws, and they may in any event allow for the, or rather domesticate the Madrid system, in which case it may ratify all marks that are on the register if that's what the legislature chooses to do. So I just put this little slide on there because it's often, trademarks, and what happened in this particular situation, the mark was Betasol versus Betnesol. And confusingly similar is perhaps aptly suggested by this little depiction of Angelina Jolie. The other day I saw an article which said there's a Russian version of her, and she's, well, to my left as opposed to yours too, if you look at the screen, and Angelina Jolie to the right. And I wanted to explain something about confusing similarity, and we often have to explain it to clients, or sometimes explain it to the other side when they don't quite get the picture. And a court will always look at distinctive elements and look at the dominant elements in a mark. So it'll look at whether what's dominant. Is the fuller lips dominant? Is the shape of the eyes dominant? And what is it that strikes you? Because we don't ever remember anything perfectly. We remember it imperfectly, and we tend to latch onto particular elements. And that's how you should think about your trademark, and that's how you should think about your trademark when you're comparing it to another trademark. What are the elements that I find dominant in my mark, and how would somebody else perceive the mark, and how would they remember the mark? So proceeding now towards the outcome of the finding, ultimately it is found that IRs can be used to rely, or you can rely on an IR that's currently on the register to oppose a mark. Enforceability, like I said, I think is questionable. I think it's open to debate as far as infringement proceedings are concerned. But at least before the registrar, they will be bound by their own judgment, I would think, to allow one to oppose a mark based on an international registration. The misgivings which I've spoken about to some extent earlier relates to whether you can exercise judicial notice the way the registrar has exercised it. I've doubtful whether domestication can be averted simply by looking and taking judicial notice of the fact that the country intends to eventually apply it. And the rulings of the court. What ruling should you look at? I think the higher court ruling should, by virtue of the statute of that court, apply and should be enforceable. And then lastly, I want to say there was an interesting development in this case where the registrar also went to look at similar goods for the marks and so on and so forth, which is traditionally not used in Zambia. So that's a new development in that we may be able to argue that if the goods are similar, that the marks are then, if they are confusingly similar, there will then be deception and confusion. Thanks, and that's it for me.
Okay, so just trying to wrap my mind around this. So you've got an international registration, a person who owns it sitting wherever. They're relying on this. They don't have a mark in Zambia. They're not using it in Zambia. They cannot necessarily point to a reputation in Zambia, and yet they're able to enforce that international registration simply because Zambia is designated as a country under that international registration.
Correct. So the procedure would ordinarily be for an international registration. You would rely on a home registration typically. So you have an existing registration, and then you designate the countries. You designate Zambia. It will be on the basis of your home registration, same goods, same mark, etc. And then the WIPO in Geneva, which is the World Intellectual Property Organization, they administer the Madrid system. Then they will do a formality, an examination for formalities, and then if they find it complies, they will then advertise the mark, and they will notify the local registry in Zambia. This mark is now open for opposition. There's a 12-month period in which third parties can then oppose the registration. That mark will also be advertised in Zambia. Well, in this instance, Zambia is now currently advertising such international registrations. So what I'm getting at here is there's a procedure. There's a procedure, the mark was applied for, like you would do conventionally with a national registration, and eventually, because there was no opposition, the mark was accepted and placed on the register in Zambia. And that's the right that they are counting on.
Okay, so does this mean anyone who doesn't have prior use in Zambia can just rely on what we call spillover reputation,
No.
or can just say, listen, I've used all over Africa, now you have to enforce my rights?
No, not at all. That was the case of DH Brothers versus Olivine, which is an SCA case in Zambia, and it was determined there that you cannot rely on prior rights. So if you have existing use in Zambia but you've not registered it, sorry for you, you can't rely on it, and it's because it's a first-to-file system. Remember here, how this is distinguished from that is that the opponent was relying on a mark which they argued is registered in Zambia via an international trademark system, being the Madrid system.
So what if this played out in SA? Would we have the same outcome? Would our judges say they take judicial notice of the international registrar?
There could certainly be a judge that might take that view, but I think that it would certainly be taken an appeal, and I think the judicial notice would be overrun by common sense that you certainly can't do that. I think South Africa, I'm confident that I don't think the outcome would have been the same. I think there would have been recognition. In fact, in South Africa, we currently have the local registry that's developing systems for Madrid, so on and so forth, but they're not accepting Madrid applications, not applying Madrid applications, simply because we haven't yet domesticated the legislation. Well, we haven't acceded yet. First you have to accede, and then they will domesticate it.
So point is, register in Zambia if you're going into Zambia.
Yeah.
Okay.
Thanks.
Awesome, thanks Jamil.
Thank you.
Darren, we move over to you. I believe that there was a case that you worked on actually, where there was a raid. Before you get into that, I wanted to say something. Hey?
Can I just have the remote?
Oh, sorry. Can you that you worked on. Godfrey gave us quite a real depiction of what raids, what happens during raids downtown Joburg. I personally was like, I would never want to find myself there. And I believe that in these two cases you're going to discuss, one was successful and one wasn't. Can you just quickly take us through what those are about?
Right, we're in the home stretch, so I'll keep this short. Firstly, I want to distinguish myself from Godfrey's conversation. This is not downtown Joburg raids, this is about remotes. Remotes are highly contentious items. As you all know, you know what it's like on the couch, and your wife's watching the rugby, and you watch that rerun of Friends. And there's normally a big, it becomes a bit contentious. Anyway, this is what happened with Ellie's and Beyond Platinum. Very briefly, Ellie's, of course, we know is the electrical store. Beyond Platinum creates these remotes that we're all familiar with, and they supply Ellie's, and Ellie's got a cheaper price from China and started selling them, and of course, Beyond Platinum became quite cross. So the judge picks up on this quite nicely in the first paragraph of the case. He says, every person in South Africa who owns a DSTV TV decoder is well acquainted with this device, possession of which could cause considerable animosity between household members. So I thought it was quite cute. Of course, Beyond Platinum immediately then sought to now get back. And how did it do this? It went and got a warrant to do a raid at Ellie's to confiscate these goods on the basis that the technology contained within the remote control was copyrighted as a computer program. They were able to persuade the judge to do that, and went and did a raid. The raid that ensued at Ellie's offices on 11 December 2017 was, according to Ellie's, of epidemic proportions. Approximately 20 people, including a dozen police officials armed and clad in riot gear, arrived at Ellie's head office During the raid, 4 million worth of stock was confiscated and the entire accounting record database as well as email servers were copied. Save for denying that all the police officers were clad in riot gear and armed, these allegations are not seriously disputed by BP. The effect of a raid is quite considerable, especially if you're quite angry. Right, of course, now Ellie's took issue with this. They issued undertakings immediately that they wouldn't, in fact, the undertakings were to recall products off the shelves and keep them in safe houses within their organization. Of course, the confiscated stuff went to particular depots. But they denied dealing in counterfeit goods on the basis that copyright does not exist in a computer program in a remote control, and put serious question marks on whether copyright existed. And then it applied to set the warrant aside, claimed misuse of confidentiality, punitive costs, and this is important, and a damages inquiry. BP continued. They actually, what happened is that they've got certain deadlines after the counterfeit goods raid has been conducted. They failed to meet those deadlines. So in order to revive those deadlines, they went and got 2 further search warrants and conducted 2 further raids, and then counterclaimed for an interim interdict. Now the judge found in favor on Ellie's on all counts. So in other words, what I'm saying, they set the warrant aside, they ordered a punitive cost order and a damages inquiry, and in fact scolded BP quite significantly in the judgment. And so, and the reason why they did this, just to go through it, is that they say counterfeiting obviously is a deliberate and fraudulent infringement. This is supposed to be differentiated from a person who has a civil case on the basis of a breach in copyright. We're talking about the things that Godfrey spoke about in his presentation, and if you weren't here, we're talking about a Nike tick on clothing that's deliberately fraudulent to sell that Nike clothing. Not this situation where you have a dispute potentially on copyright within a program. And a copyright is one of those rights that exists automatically, it's not registered, and there frequently are disputes of fact or disputes of law around the existence of copyright. And so you can just read a bit further. He really went to town on them and issued a cost order quite recently in May, and this judgment has been taken on appeal. But I'm going to contrast this with another order. At the same time, December 2017, in fact, we were an insurance company, had an issue with their employees, which they had tracked emails, taking confidential information and copyrighted material, and wanted to stop them. They thought they were, and I believed that they were setting up a competitor firm, and as a result, went and got an Anton Pillar order, which is a raid of sorts. It's there to preserve evidence. We went to a High Court judge, persuaded him that this was a real threat, and he ordered the Anton Pillar order, and the raid took place not with 20 riot gears, but riot police, but it was quite invasive. The material was retained, and they immediately applied to set that aside, and on the basis of urgency, but failed to do so. Why I'm talking about both of these cases is the following, is that raids are particularly useful. And you can see the effect of a raid. And very often when there is a heated debate, people want to take the most aggressive action possible. And a raid immediately comes into a possibility. And there are various ways of doing a raid. The Counterfeit Goods Act, there's a Copyright Act and the Criminal Procedures Act, and the Anton Pillar order. And these are, and I'll go even as far to say as a takedown notice of let's say you've got a site and you want to take down even a web page. These can be done without notice. And as a result, I'm just looking at Mike Gormley over there, who does a lot of these himself. One has to be very careful about chomping at the bit and doing these raids. So how does one raid with confidence? And really what I want to get to is some lessons from these cases. So what are the lessons? When do you take action? When do you not take action? Firstly, we see search and seizure orders are very effective. If you want to get someone's attention, do one of these. But you must be full, frank, and open in all instances. You've got to be almost over the top, squeaky clean in front of whoever you go to. And you must have certainty on aspects of the underlying infringement. While you might win that little battle, in other words, do the raid, you will certainly not win the war if you do it without having that legal certainty. If there is any uncertainty, inform the other side and give them an opportunity to respond. So what happened in Ellie's, had they informed Ellie's of the raid, of the copyright claim, and they did not challenge it, then it would have given greater grounds to do the raid. Of course, when you do these raids, I'm not suspecting that you give your counterfeiter for the Nike tick on a T-shirt a notice that you're going to do a raid. Obviously, that's not going to work. But there are certain instances that one must assess this. And then you must have a proper copyright management process in place. And this is happening more and more because software is more and more in the realm of people taking software within organizations or alleging and ownership of, as you know, copyright is the main way of protecting software. And so having a process in place where you can identify the author and prove copyright ownership is critical to being successful. So just a bit of pre-planning. And again, just to stress, and my final point really, is that raids are often contemplated in a time of stress and emotion. There's a knee-jerk reaction and sometimes pressure on that attorney to assist his client. And the attorney really has to just be very careful about how they go and get the information and deal with this matter. And I guess there's a bit of education involved there. But maybe by stressing what can really go wrong, and especially the cost, is something to consider. Thank you very much.
Thanks, Darren. And thanks for getting to those lessons. Now, what I want to understand is, I have a 4-year-old who's slightly taller for his age, and he started raiding the pantry. Do those lessons apply for him? Do they apply to him? Especially the search and seizure.
Yes, it's even more important, Lisa. Your 4-year-old kid is far more sharp than any of us adults.
Give him notice.
Like that's going to work. So, Darren, on the real, are raids expensive?
Ask Godfrey, and you'll say they're very affordable. I think in the context of civil litigation, raids are actually not, relatively speaking, that expensive. You can get a raid done fairly quickly. All you have to do is prepare an affidavit, go to, we went to a High Court judge. It's a simple application. There's no notice. And so those initial costs are not significant. Right? What is really costly is what might happen next. So if you do a raid and they are going to, is a threat that it may be set aside, that's when the costs come in. Suddenly you want senior counsel, suddenly you want your guns in a row, and really that's when costs get out of hand.
I was actually coming to that because I wanted to know, you keep saying no notice, and that sounds good and well, but what are the ramifications if you get it wrong?
Well, I think that's it. So, it's a really invasive procedure. So it must be used with caution. It's very effective, and it's very effective when used in the appropriate circumstances.
Okay, awesome. I think I'll leave it there with you. I want to jump onto Slido and see the questions that we've got. Gerard, I see you're rather popular. Everybody wants to know something from you. Guys, put some for Darren, please, man. And Jamil.
It's okay.
I'm joking, shame. I have the mic. He is my boss. I'll have to deal with this afterwards, but you know. So let's go on to the first question. This one is for you, Gerard. What are the preventative steps that a brand can take to avoid infringing on another brand's IP?
Lita, the very easiest way is don't copy. Of course, a fair measure of copying is allowed, but don't. Just be inventive and come up with your own creative, original elements on your packaging and on your product. So that's the first step. But also be aware of what is happening in the market. But normally you are aware of your competitors' products, and just make sure that you're not trying to get too close to that.
And if you decide you're going to kind of do it anyway and you get a lawyer's letter, what the hell do you do?
Well, don't give up too quickly. Remember, it's a bit of a grey area. There are always arguments both ways. So, and there might be a variety of products and competing products with similar elements or similar get-up. So the fact that there's one competitor telling you that you must stop because you look too similar. It might be the industry norm. There are a variety of types of products in the food industry, in other industries, where they are color coding to certain types of products, and nobody can claim exclusivity in that. So just take a step back and take a bit of a view of what's happening in the marketplace.
Okay. The next one is for Jamil. Are IRs, which is international registrations, advertised for opposition purposes?
Before I answer the question you asked, Gerard, what's the first thing you do when you get the letter? Contact Adams and Adams. Yes, IRs are generally advertised for opposition purposes, and talking specifically in Zambia, that is currently the circumstance. They do advertise them. I must say it was not clear from the case that was before the registrar whether the IR that was relied on was advertised at that point and whether it was examined. I understand informally from the registry that they, in their words, steamrolled some of the IRs onto the register. In other words, they did not examine it, and when there was no opposition, they simply entered it onto the register. But currently, they are advertised, yes.
And sticking with you, has that Zambian decision been appealed?
To my knowledge, not yet, no.
Okay. Gerard, to get back to you, in the case of Bolt, which was formerly Texify and rebranded completely, can they still claim residual reputation?
Well, I think it depends on the circumstances. So if the rebranding is a complete change and almost an abandonment of the previous trademark, I think you will lose your residual reputation quicker. But it's a factual question, and in the case of Nivea, we were able to prove it just with reference to the market share and sales. But otherwise, you might have to do a survey, use the old name and see whether consumers still recognize that. But there will be a period of time that you would still be able to enforce rights in your abandoned trading style. That I think you can do it.
Okay, next question. I like this one. What is the practical consequence of the Nivea judgment? What would happen to Connie's stock on hand bearing the offending marks?
Yes.
Sell out or destroy?
The case under appeal at the moment. So I think we should be heading to Bloemfontein probably in May next year. So in the meantime, the judgment has been suspended, but if it gets confirmed, not sell out. You're not allowed to manufacture or distribute anymore. And there's a delivery up. So all the products or packaging must be delivered up for destruction. But the goods already out in the trade, and you can't retrieve that, that's out there. But any goods still under their control or in possession of Coney multinational must be delivered up for destruction.
And if that judgment is upheld, are they going to be asked to pony up?
I think so. There's quite a lot more to this case. There was a lot of sort of political involvement. Just in case you didn't know, the Connie was the name of the proprietor, Connie Ferguson. I didn't knew her that well before the case, but
now
she's a bit of
know
a celebrity.
Her.
I know her now. She was a star in Generations and tried to cause quite a lot of difficulty also on social media, but it backfired. So her following initially told buyers to back off, how dare you, and they started a group Hands Off Connie, but as the case went on and they saw examples of the products, they started telling her, why don't you just stop copying? So it backfired a bit, but I think we will certainly look at that.
No, good. I'll skip over to a question for you, Darren. Did Ellis get their stock returned?
Yes, they were set aside. Of course, the other side, BP, appealed the judgment, of course. So what will happen now is that the judgment's ineffective or pending until that goes through. So we wait to hear. In fact, I was hoping for their counsel to be sitting right here, and you would not hear my dulcet tones, but he of course, is conflicted and not able to comment at this stage.
Okay. I'll take one more for you, Darren. What are the legal sanctions for selling counterfeit goods?
There are two, really. There's obviously you've got a civil route and a criminal route. The civil route, you can get your normal civil damages, including reasonable royalties. From the criminal side, it's an offence, and there's a fine per item of counterfeit goods per article.
Okay, I think I'll take one more. Okay, why don't places like China Mall in town get closed for selling counterfeit goods? Godfrey, do you want to take this? Do one of you want to?
No, I think Godfrey must do
Godfrey,
this.
you're in the room.
Definitely.
Come.
We don't have any problem with them. Our effort is not to shut down businesses. In any event, we need these businesses to grow the economy. We are only against criminality. We are only against people who are selling counterfeit goods, which is against the provisions of the Counterfeit Goods Act. So we can't shut down China Mall simply because of the name. No.
Okay, thanks. Godfrey's very adamant. I like that. Okay, with that, thank you so much. This was really good. It was nice, short, and I'm there for the time. I want things to run like clockwork. I think that brings us to the close of Crammer. Is it fine if I sit, guys? Can I?